Assalamu alaikum. Good afternoon. If I look a little bit dazed, I can explain in just one sentence. I went for a meeting in London, and the night before I finished the 3-day meeting, it was confirmed that I have to go to the United Nations for a meeting of experts on a subject which is very close to my heart. And I had to go, I couldn't refuse. And then from New York, I flew back to Dhaka. And after one day, I had to go to Colombo. From there to Jaffna, back to Colombo, now to Dhaka. I don't know whether I'm coming or going. And if you can't understand what I am saying because you think it's either Tamil or Sinhalese, please forgive me. Now, Anita keeps telling me that this institution, think legal, I think it is becoming an institution, has come about because of me. Well, that's not quite true. She has done it, and all credit should go to her and her team. I think, well, she keeps telling me or reminding me, I don't know whether it's exactly true or not, but apparently at some point in time I told her to do this. What I do remember is that she came to me and we talked about, or she talked about, a publication. And I said, more than a publication, there should be dissemination in open forum. And I believe this is the outcome of that suggestion. Now, today you have heard from morning till now, and I'm sure you're all very tired, want to go home, and so do I, about business law, energy law, company law, tort law, corporate accountability, banking practice, contractual rights and obligations in each jurisdiction. Very wide-ranging topics, but very important topics, no doubt. I see among you very young and promising lawyers, and I do believe sincerely that this type of a gathering, conference, seminar, workshop, whatever you like to call it, will be for benefit for all of you. Now, some of the things, I missed most of it, but I did get engrossed. I got engrossed in the tax law in the next room. I was so engrossed that I was drowned. I couldn't come back here. Tax law is something I always try to avoid. I understand it very little. But anyway, I depend on the lawyers to tell me what the law is. If both lawyers can tell me what the law is, then I can say, well, you're wrong and you're right, and that's it. What I would like to say about the law, any law, is that laws are only as good as you make them. And who makes the laws work? It is the lawyers. The judges are tied in their hands because they are to, first of all, hear arguments on both the sides from the lawyers, their interpretations, and then they are to make the decision in accordance with what they believe is the correct interpretation of the law. We have heard many things from my friend Barrister Akhtar Imam. It was very challenging to listen to him. I mean, he's only saying these things because, you know, when I was elevated to the bench, everybody congratulated him because they thought he was elevated to the bench. They knew him more than they knew me, obviously. The problems that we are facing in the courts these days, sadly, is because, particularly in the arbitration field, I can say, is because abuse of the process. Certainly, the law on arbitration made for expeditious hearing. It was supposed to be informal and inexpensive. Informal, well, in certain arbitrations, I can say it has been informal. I have taken part in many arbitrations as a lawyer. I appeared with other renowned lawyers before the likes of late former Chief Justice Bodur Haidar Chaudhry, Abdul Bari Sarkar, and many others. And I can say quite categorically that those hearings were informal. But as I understand it, more and more they are being formalized. I would suggest that it only takes a minute of the lawyer's time to say to the judge, if he is being formalistic, that this, sir, this is not a formal hearing. Sir, this hearing is such that the laws of the Civil Procedure Code, Evidence Act do not strictly apply. I think once you remind them, they will understand where their position is. But the abuse happens, if I can say it this way, and please forgive me if I say it like this, as a result of the activities of the lawyers. I did say forgive me. Will the lawyers have the professionalism to tell their client that he cannot be used, the lawyer cannot be used to promote the nefarious tactics of the client? Will the lawyers tell his client that this is not possible, what you want to do is not allowed by the law, and if you don't like me, go to somebody else? Will the lawyers do that? I wish they would, because that would be the proper advice from a good lawyer. Arbitration is supposed to be over in a jiffy. I remember one arbitration case that I did particularly remember it because it took so long. 3 of my predecessors, I was the lawyer for TCB. 3 of my predecessors had gone through the same case. They had all failed to get the final decision. Not failed to get the relief, no, that's a different issue. But they failed to get the final decision. The case started in the year 1966. And it wasn't until probably 2000 or something like that, 1999 or 2000, when I got the final judgment in favor of TCB. And guess what? I got the judgment, and the company that I got the judgment against had already become bankrupt and had gone. So what did I win? Yes, $66,000, equal to 0, because there was nothing to get. And why? Because there was a very clever, eminent lawyer involved on the other side. So, if the client can pay for a lawyer who will do his bidding and delay the case, put in application after application, who's losing? 1, the opposition, of course, and 2, the system. The whole justice system is being defeated. I believe you will all agree that we should be honest to our profession. We keep telling lawyers, please remember it, you are an officer of the court. So you are. Will you deny it? And when you are an officer of the court, you are duty bound to the court to be honest to the law, not just faithful to your client. Being a lawyer for your client brings you money. Being an unscrupulous lawyer to your client brings you more money, but it brings you less fame. I can tell you that. The other thing that we should all remember, particularly when we are trying to dispose of cases, is that both the lawyers and the judges, and here I agree with my friend Mr. Akhtar Imam, both the lawyers and the judges are responsible to the system to ensure that justice is done. The judge should be equally astute to realize where he is being led up the tree for gains of a particular client. Our problem, unfortunately I have to say this, our problem that our whole system is unfortunately not geared towards imposition of costs. I have seen in many other jurisdictions, cases fall through. The client doesn't want to go ahead. Sometimes even where the lawyer says, yes, there is a 50-50 chance, the client will say, I'll hedge my bets and I'll let it all go. I will save the rest of my money. But that depends, particularly in our scenario, on good advice from the lawyer. The lawyer has to be honest, not just to his client, but I believe he also has to be honest to himself. Is he practicing in a proper way, in an ethical way, if he advises his client to go ahead only because he will pay him a good fee? You're all very quiet. It's a very serious matter. But I believe it is worth thinking about. You're all very young lawyers, most of you. And I hope that you will all consider being lawyers, good advocates. Make a case, of course, but make a case within the law. Win a case, certainly, but win a case within the bounds of the law, within the ethics of the profession. We have had examples, and Mr. Akhtar Imam will bear me out, where lawyers simply use their tactics to delay, and the client will pay him more and more because in the long run it saves him more money. If you have a case of hundreds of crores of taka, paying even 1 crore to the lawyer doesn't matter, because 99 crore taka sitting in the bank is earning him more than he can pay to the lawyer. It's worth it. But we should all be there to ensure that justice is done in accordance with the law which is before us. Mind, we cannot bend the law. We cannot change the law. Judges cannot change the law. We heard about directions from the Chief Justice. Yes, there is provision for making directions by the Chief Justice. But the Chief Justice cannot make directions which are contrary to the existing law. Chief Justice can give directions on how to apply the law if the law is being misapplied. We have had a number of instances where Chief Justice has given directions on procedural issues. For example, the Chief Justice can say that you are supposed to complete this case within 120 days. Why have you not done it? Or that the judges are bound by law to conclude this case or this type of case within 160 days, and it must be done. That much he can do. But if the law allows for disposition of a case within 160 days, the Chief Justice cannot say you have to dispose of it in 130 days. We are all bound by the law. We have many laws, I believe, which are contradictory to each other even. They don't always come to the fore. That is the fault somewhere, possibly in the drafting department of our law ministry, because there is no assimilation of existing laws. We have laws, provisions, not laws, but provisions of laws which are conflicting with provisions of other laws. Here there should be assimilation. If a particular existing law is being amended by a different law in another statute, then there should always be a cross-reference to say that this law has been amended by such and such a statute. But this is not done here. It's very apparent in some of the laws that we are seeing coming out of the ministry. Arbitration is supposed to be quick and quick relief for all the parties. But if the arbitration takes years and 20, 30 years, as Mr. Akhtar Imam has told you, then it defeats the whole purpose of arbitration. We have seen many cases. I believe we have recent decisions on arbitration issues, and I can't remember offhand the cases, but two recent judgments that I have delivered, that I have written, I should say, in the Appellate Division, where we have dealt with certain stages of arbitration where illegalities have been committed during the process of the trial and the final adjudication. So we should all try to follow these. Only when the lawyers and the judges work hand in hand to deliver justice properly will the justice be delivered. It is easy to bring a case. In our system, it is so easy to put in an application even before the High Court division, to put in a motion before the writ bench, and even to get a rule. Sadly, I have to say that in many cases, rules should not have been issued had the judges and the lawyers helped each other by showing elements of the Appellate Division which have already decided the issue. I would urge all of you to look at our decisions. These days it's very easy. Uncle Google knows it all. Even apart from Uncle Google, we have BDLEX and other, I think, electronic media which will give us decisions of our courts. We have our own website, the Supreme Court website, which will give you copies of our decisions. If you look through them, if you just search, you will find whether or not the point you are arguing or you're going to argue is there already decided. You tell your client, this is a hopeless case. Here is the decision that goes against you. I have seen practitioners such as Mr. S.R. Pal. I remember very vividly one particular case that I watched of his in the Appellate Division. Very unassuming person. Many of you will not have known him, but you will have only heard of him. He stood up and he said, "My lords, the case in brief is this. These decisions, A, B, C, D, etc., will support my case. My friend on the other side, he will argue this, and he, in support of his case, will possibly refer to these 1, 2, 3 cases. But those 1, 2, 3 cases are distinguishable from the facts of this case. And he will show the distinguishing features, and he will sit down, and that's the end of the matter." That is the type of assistance that judges appreciate in the court. Do we have any such lawyers now? Few. Sadly, I have to say that lawyers these days don't even refer to cases. I remember a time when I was practicing, when I was a student of law. The first thing we were told to do was look at the facts and then rush to the decisions and see which case is on all fours. That was the phrase we used to use. Is on all fours with the facts of your case. If you're lucky enough to find a decision, that's enough. And I remember doing precisely that. Spending hours deep into the night looking for a decision. And if I found it, eureka! This is what I need. I go to the court, I say, "My lord, this is the decision." They can't deny it. Conversely, if you find a decision which is against you, you should not try to hide it, just for the sake of your client. For the sake of your client, you should tell him that, look, I may think you have a good case. You may have a 50-50 case. But here is this decision which is against you. And even if I don't tell the court, the other side might. So let us be prepared for it. Will you do that? I hope you will. Because that way, the court will have an easier task to decide the issues. You're all very tired, I'm sure, after a long day. I'm very tired, I know, after a long journey. London, Barcelona, New York, Dubai, Dhaka, Colombo, Jaffna, back to Colombo, Dhaka. I don't know where I am now. Thank you all for listening to me. I believe this is a very good initiative taken by Think Legal. I hope we will have many more of these. Certainly, the attendance here today shows that it is a popular occasion, it is a popular function, and it will be useful for all of you. I thank you all very much for listening patiently and wish you all a good evening.